Hello and welcome back to Questions That Matter, where we discuss the important and interesting work that we are doing here at TrustBridge. Today I have with us our Managing Director, Dr. Renuka Sane, and we will be talking a little bit more about our paper on insider trading and SEBI's regulatory orders on insider trading. Welcome, Renuka.
Thank you.
So we've previously talked a little bit about the methods and the framework that we use to evaluate SEBI's orders on insider trading, and we've also talked a little bit about how they do in appeal. So how do SEBI's orders do in appeal at the Securities Appellate Tribunal, or the SAT? But let's dig a little bit deeper into SEBI itself and their orders. So SEBI can impose different types of sanctions, and one of them is penalty, of course, but they can also impose certain other sanctions. So there's debarment, which means that you cannot access the capital markets in any way for a certain defined period of time, whatever SEBI says. You can have disgorgement, which means that any unlawful gains that you have made because of insider trading or pursuant to insider trading, you have to disgorge. And then the fourth type is restraint from capital markets. So these sanctions should only be imposed if there are certain violations of the insider trading regulations. And broadly speaking, there are four types of violations of the insider trading regulations. One is the unlawful trading in securities. Then is the communication of unpublished price-sensitive information. Then there could be a violation of the code of conduct that is specified under the PIT regulations, or it could be any other violation. It could be a disclosure violation, for example, under the insider trading regulations. But in this case, for insider trading, there are certain essential components of the violation that need to be fulfilled in order for SEBI to impose a sanction. Now, my question to you is, are those actually being fulfilled? And more specifically, is SEBI even establishing a connection or an insider relationship before it's imposing sanctions?
Thank you, Natasha, for that background on what the exact offences are, and to answer the question on establishing connection. I think that the answer is mixed. It's yes and no. So in about 60% of the cases, SEBI does very clearly establish what the connection between two people is. But, 40% is still quite a large number where the connection is not explicitly defined. Now, you may want to give SEBI the benefit of the doubt, because in, the zero connection is only in 14% of the cases. In the rest of the cases, SEBI is able to describe the connection. Now, if you go with a very strict definition of how an order must be written, I would say that the connection must be specified very clearly. Then you are at 60%. But if you are a little open to just the connection being described but not specified, but even then, 14% of SEBI's orders do not describe a connection. Now, this is pretty serious, because your entire sanction rests on the fact that somebody is an insider. And therefore, it has to rest on the fact that how that person is an insider has been clearly established. And there are some weaknesses on that front.
And can we talk a little bit about the definition of insider? So SEBI sort of expanded the definition over the years. So can you tell us a little bit about that?
So, earlier it was an insider is only someone who's a connected person. But I think, and this is not new, I mean, this has happened in much before we were looking at, from when we start looking at the data, which is that two new definitions of insider trading in some ways, or an insider really, have come up, right? One is someone who's deemed to be connected, and a third is someone who has access to UPSI. Now, both deemed to be connected and has access to UPSI are far more ambiguous than a connected party. Because when it's a connected party, it's very clear what my relationship to you is, and therefore how I might have gotten information from you. But when it's deemed to be connected, it could be as simple as we being Facebook friends, or finding ourselves in the same building or in the same elevator, or having a long-winded connection through, some 5 layers of family.
Yeah.
And then that makes us deemed to be connected. Now, that is quite problematic because it's harder to establish, and the onus of the proof is on the accused. Now, when you start doing that, then the content of that definition becomes even more important. So, A, it's an ambiguous definition. And B, now how do I prove that even though I'm your Facebook friend, I actually haven't spoken to you for 15 years or whatever it is, right? Or that, while I met you at dinner, but I didn't really talk about information of a specific kind. Those things become very difficult to describe or to prove. And I think that's also interesting because over time, what we have seen is that the number of orders that SEBI has passed where the alleged violator is deemed to have been is connected are just increasing in number, and the connected violators are actually falling. So what it means is that SEBI is more and more going against people where it finds that they're either deemed to be connected or they have access to UPSI. And these are in some ways troubling because they are very ambiguous. And as I said earlier, the burden of proof is on the alleged violator.
And is SEBI also concerned about the number of violations that one person has done? So let's say that I have communicated unpublished price sensitive information or UPSI to you. Does it matter that I've just done that communication or whether I've actually traded? How is it looking at the relationship between the number of violations and the sanctions?
My intuition or my prior was exactly the same, but we didn't really find a relationship like that. So sometimes we find that there is only one violation where the penalty is higher. Sometimes a person has committed 3 violations and the penalty is lower. So that relationship is a little bit all over the place. Now, of course, if I was SEBI, I would say that a trading violation is very different from a code of conduct violation, and therefore you can't compare the two. So 2 violations, which includes code of conduct and disclosure, are far less damaging than, let's say, 1 violation that is unlawfully trading in securities. And so we get that, right? We appreciate that the number is not all that matters. But even then, if you look at just UTIS and UPSI, which are the more damaging violations, there is no clear relationship that if you've done both, then there is a higher violation versus if you've just done one. So it feels like SEBI officers have their own point of view on how they arrive at the penalties. Very often we also find that they impose the minimum threshold, right? So they just say, look, I can't arrive at the exact number, and so what I'm going to do is just give you the minimum threshold, and maybe some of it is driven by that. But I guess the inference to make from that clearly is that there is no set pattern. It is entirely up to the discretion of the adjudicating officer or the whole time member on the amount of penalty to impose, and depending on how many violations there are or how serious the AO or WTM thinks that violation is at that point in time. There is no information in the order that tells us how they were thinking.
But there is something in the SEBI Act that tells us how they should calculate penalties, right? There is Section 15J of the SEBI
That's
Act,
right.
which has certain factors that should be taken into account when thinking about the quantum of penalty. Now, the Supreme Court has said that this is not an exhaustive list.
Right.
But are we seeing SEBI look at these factors at all?
Again, the evidence is mixed, that we find that in about 20% of cases by the adjudicating officer, there is some mention of the amount gain or loss avoided. The WTMs do better. That number is at 76%. So 76% of all WTM orders do mention something about the amount gained or loss avoided.
Mm-hmm.
But that's it. So 26% is or 20% by AOs is a very poor number,
Mm-hmm.
which means that the AOs are not able to identify the amount gain or loss avoided, and 25% by WTMs. It's pertinent to point out that WTMs are listening to the more important matters in some sense. So the UTIS and the UPSI cases are surely being heard by the WTMs. And that's where it should be easier to establish the amount gain loss avoided, because maybe in a code of conduct violation, there is not much to be established, and then you put in a minimum threshold.
Hmm.
And so if you just look at the WTM numbers, it's still 25% of the orders that do not have any mention. What is also interesting is in a large proportion of the orders, they kind of say that it's not possible to quantify loss to investors.
Hmm.
And I find that troublesome again, that it's such an important part of how you think about arriving at penalties. But you yourself are admitting that it's just not possible to quantify it. It raises the question, why have it there? Or can we do something to improve our ability to measure these kinds of things?
And on that note, do you have any suggestions for how we can improve SEBI's adjudication of insider trading, or specifically on the sanctions?
Look, I think part of it is that there have to be better manuals that prescribe how adjudicating officers and WTMs can calculate some of these things. But I also think that some of it, is shaped by incentives, and the incentives have to come from above. And when I say above, it means SEBI board, but it also means SAT. That if you start to lose cases because you have not quantified 15J factors, then that is a push to SEBI to now start taking this seriously. Because, it's human nature, it's public choice theory, that you are only going to do what you are incentivized to do. And, we need this two-pronged effort, that more cases have to go to SAT, where they challenge how penalty amounts have been calculated. The SAT needs to take cognizance of this. The Supreme Court needs to take cognizance of it. Like you said, the Bhabesh Pabari case, actually, the Supreme Court said that you can look at factors other than 15J. So in some sense, the blessing from there is coming from the highest court. So we do need some recognition of this by the tribunals and the courts, and by the appellants who can use this to challenge the way SEBI is thinking. But we also need SEBI itself to realize that perhaps it can do better by investing more in some of these methodologies, and in kind of agreeing or articulating the idea that an order needs to contain all information. It's not just about what is on the AO's mind. Whatever is on the AO's mind, whatever discretion that AO might have, that has to get translated to the order. So nobody is saying that discretion shouldn't be allowed, sure, but the rationale for why you have chosen certain things, you owe it to the regulated entities and to the citizens of this country to explain why you have taken a particular stance. And I think that realization needs to also come within SEBI. However hard it might be to do this, but I guess that's the point.
Yeah, definitely. Thank you so much, Renuka. Thank you so much for watching. Please remember to like, share, comment, and subscribe. Please share this video with anybody who you think might be interested. Thank you.